Court is calling. Are you,
Which ones are they for?
I'm sorry, what's your name, sir?
Gilbert Solinas, Judge.
All right. This is Zion.
I'm sorry. Check.
Cindy, are you ready? Everyone, please whisper. Court is calling 2024 CR 0127555. State versus Gilbert Solinas. Can I have parties announced?
Joseph Appelt for the defense.
And are you Mr. Solinas? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Solinas, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes.
Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are proceeding with the lesser included.
Arson to a building belonging to another judge.
I'm sorry, arson of a building belonging what?
Belonging to another, I believe it's A-2 subsection 1 of the code 28. I can't remember the last two digits, Judge.
All right. Any objection?
No objections, Your Honor, no.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yeah.
Did you understand the state is proceeding on the lesser included offense of arson to a building belonging to another as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is and was.
Mr. Solinas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of arson of a building belonging to another. There's a $2,000 fine. State recommends deferred adjudication. There should be restitution, if any, to the Henry B. Apartments. Did you understand that to be the plea?
Yes.
Defense?
That's correct, Judge.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
There are no such motions.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years, TAP evaluation, 200 hours of community service restitution, and no contact with the Henry B. Apartments. Did you understand? Those are recommendations from the state, and the court does not have to follow those recommendations.
Yes.
Then to the offenses, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
We'll talk about that. I'm taking responsibility.
I take the
No.
You have to plead.
Guilty, not guilty, or no contest?
guilty.
State, any evidence?
State offers states exhibit 1 and follows action sentence on your honor.
No objections, Your Honor.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
With permission of the court, yes, Your Honor.
Anything you wish to say on behalf of your client?
If it pleases the court, Your Honor, I have personally known Mr. Solinas since 2011. He was previously a professional boxer, and I would represent to the court that the Gilbert Solinas I know and what is described in these records, what happened this day is an aberration and is completely out of character of this gentleman. I would also let the court know that since the arrest on this case, approximately a year ago, he has been supervised by the pretrial services where he's been on a GPS monitor. He has 0 violations. He's also participated in the form of an outpatient program with the Center for Healthcare Services, dealing with one of the issues of that day, which was he doesn't normally drink. However, he had consumed some Japanese liquors, is what I'm being told, which was brought over from Japan by his daughter that day, which unfortunately influenced him and made him act completely out of character. He has taken responsibility for this, Your Honor. He is a over-the-road, long-haul, independent truck driver. He's currently employed with a company called 381 Logistics out of Chicago. He does drive over the lower 48 states. He's out of town for about 4 to 6 weeks at a time. During that time, he has been on GPS tracking. He has had 0 violations whatsoever. We're asking that that be taken into consideration with respect to his probation, his deferred adjudication, community supervision as well.
All right. All right. Have you had any contact with the parties involved?
No,
I don't think we had.
Your Honor, they moved out of that apartment complex and have been out of that complex for almost this full year as well, Judge. And they live pretty much about 15 miles away now, is my understanding, with still within the same Bear County, but however, quite a ways from Henry B Apartments.
All right. Have you ever had any mental health diagnosis?
Mm.
Have you ever used drugs in the past? Do you have any children that are minors?
Mm.
Do you have any grandchildren that are minors?
yes,
8, what is the age?
1,
All right, this is what the court is gonna do. The court is gonna sentence you to 5 years deferred adjudication, regular reporting by Zoom or in person, no contact with the Henry B Apartments, restitution, if any, to the Henry B Apartments, Max G. Solinas, Edgar Ochoa, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, and the defendant is allowed to travel for work. And there's 200 hours of community service restitution. There's a $2,000 fine, and that will be probated. Field visits 1 time per month for 3 months. Probation, is there anything else?
Judge, allow for travel throughout the United States, correct?
Yes.
And no contact leave, you're going really fast.
Oh, no contact with the Henry B Apartments. Restitution, if any, to the Henry B Apartments, to Max G. Solinas, Edgar Ochoa, and there's to be no contact with Max G. Solinas or Edgar Ochoa.
If I may, Your Honor.
Yes.
Max Solinas is Mr. Solinas' adult son. Could we change that to no HOI, no harmful or
Well,
injurious contact?
if Mr. Solinas, Max Solinas, sends the court information that he has no objection to no harmful or injurious contact, I will do that.
Very well.
With
And
regards to the GPS, once parties have reached out to the complainants, I'll consider removal of GPS.
okay, in the meantime, it stays on.
Yes.
And with respect to the community service hours, at some time, since he is on the road quite a bit, would it be possible for him to purchase some of those out?
Yes.
Okay, And he would coordinate that with probation, correct, Judge?
Yes, and probation, he's allowed to purchase hours, and I'll do that at $7.25 per hour. All right, is there anything else you need from the court? Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, thank you.
Thank you, Judge. May I be excused?
Yes. State, did y'all make your
All right, let's talk about that. This hearing involving Gilbert Solinas had just about every procedural twist you could think of. Yet Judge Boyd navigated it with her usual unflappable presence and a steady focus on the facts. Mr. Salinas pled to a lesser included offense of arson involving a building belonging to another. And while that sounds dramatic, the hearing itself was measured and surprisingly matter-of-fact. From the outset, you could see that Mr. Salinas was composed and responsive, answering the judge's questions politely and without hesitation. He didn't shy away from taking responsibility, though he did briefly start explaining himself mid-plea, before his attorney gently reminded him to pick one of the actual plea options. That little moment of wanting to elaborate almost felt like a slip of honesty that, in a way, made his demeanor feel sincere rather than evasive. His lawyer provided a thoughtful statement about Mr. Solinas's background, painting a picture of a man who'd spent years working hard as a long-haul truck driver and who'd never been in trouble before this incident. The defense emphasized that the conduct that day fueled in part by what sounded like a bit too much imported Japanese liquor was completely out of character. That detail drew a faint note of irony. A man who spends weeks at a time driving responsibly across the country managed to derail everything in one afternoon. Still, there was no attempt to shift blame, and both the defense and the state stayed professional and prepared. The courtroom atmosphere was calm, with no fireworks from either side. Even the practical considerations like how to handle GPS monitoring and whether Mr. Solinas could buy out some of his community service hours due to his travel schedule were handled respectfully. Judge Boyd struck a balanced tone, acknowledging the seriousness of the offense while also allowing some flexibility for Mr. Solinas's work commitments. When the topic of no contact orders came up, it was clear she was willing to tailor conditions appropriately, including the thoughtful adjustment to permit no harmful or injurious contact with his adult son if everyone agreed. It was a good example of the court adapting rules to fit real lives without compromising accountability. Ultimately, the sentence reflected a mix of firmness and practicality: 5 years deferred adjudication, probation conditions, restitution, and community service with a path to resolve obligations responsibly. Watching this unfold, you got the sense that everyone recognized this was a regrettable but isolated lapse in judgment rather than a pattern of reckless behavior. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,